Hello, I'm David Greig and I'm a lawyer. The information contained on this video clip is about wills variation law. It's not specific advice. If you need specific advice, you should give me a call. We can discuss your situation. At the end of this video clip, I'll give you my phone number and I'll provide you with my email address. Wills variation law in British Columbia is specific to this province. So when you read cases about other circumstances that have arisen elsewhere in Canada, you may find a difference between the approach taken in other places and British Columbia. That's an important distinction to keep in mind. The basic principle behind our wills variation legislation is this. If your spouse or your parent has died and not fairly provided for you in the will, in that person's will, you may have the right to apply for relief under British Columbia law. That means that you would ask the Supreme Court in this province to vary the will to provide properly for you. Now, there are some important rules about how this works. Not everybody has this kind of an application, and there are some significant limitations on the power that the court has to adjust a will. One limitation on the court's power is that the action taken by the complainant has to be brought in a timely fashion. You have 6 months from the grant of probate to bring your action. If you don't start your action in 6 months, your remedies are gone. A second limitation on this power is this. Not everybody can bring the application. The friend at work and the neighbor down the street, they don't have rights under the wills variation legislation. It's only the spouse of the deceased and the children of the deceased. Now, the spouse of the deceased can be a common law spouse, provided that those parties live together for 2 years immediately preceding the death of the testator. It can also apply to a common law spouse or a same-sex relationship, not only to heterosexual spouses. Secondly, the children of the deceased can bring the claim even though they may be adults. It doesn't just apply to people who are under the age of 19. A third limitation on this principle or writ of recovery is that the circumstances regarding the estate, the size of the estate, and what was left to each of the beneficiaries will be an important consideration. Not everybody who has a complaint about what their mother or father or spouse left them is entitled to relief. The court will look at all the circumstances, including the size of the estate, what assets passed outside the estate, and what the circumstances of the claimant are. If you call a wills variation lawyer for advice on this, the lawyer will ask you about the circumstances of your family, and quite often it's easy to assess the validity of the claim from the outset. Keep in mind that in cases like this, there will often be hurt feelings and other emotional aspects to the claim that have to be assessed. Talking with a lawyer in a confidential interview can be very helpful. When you meet with a lawyer to discuss a wills variation claim, your meeting is covered by solicitor-client privilege, and that applies even if you don't actually hire the lawyer. So for instance, if you call me and say you want to discuss your estate affairs with me, and we have a meeting, I can't share that information with anyone else unless you specifically authorize me to do so. There's a privacy and confidentiality element to our meeting, and that's important and it has to be preserved. Another point that sometimes arises during these conversations is that parties are sometimes worried about where their case will go. They don't want to go to trial. They're worried about causing trouble and what the legal expense will be. I can explain those things when we get together and meet, and sometimes I can give that advice on the phone. The bottom line is that litigation isn't for everyone. However, if you've been treated unfairly in a will, you may want to consider finding out what your options are before you decide what to do. Meeting with a lawyer for a half-an-hour consultation is free at this office, and we can give you advice and information about what your options are and what it might cost. Most estate litigation cases are done on the basis of a contingent fee, which means that the client doesn't pay anything for the legal work unless they're successful in the lawsuit. If there's success in the lawsuit, then the client typically pays something between 20 and 30% of what they recovered as a legal fee. The second thing about that you should know is that no lawyer has the power or capacity to persuade anyone to start a lawsuit if they don't want to. If you want to come in and meet with a lawyer here and get some advice about your estate options and your litigation options, you can do that. I hope that's some help. I know it's just general information. If you want more specific information, you should give me a call. I'm usually pretty good at getting back to people in about 24 hours. My phone number here is 604-496-5096, or you can reach me by email at david@southcoastlaw.ca. Thanks.